It is 6 o'clock. Can we start the session, sir?
Yeah, it can be, sir.
Thank you, sir.
Okay.
Good evening. A warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today His Lordship Honorable Mr. Justice R.B. Budihal, former Judge, High Court of Karnataka, Judicial Member, Karnataka Administrative Tribunal. Sir, we are both honored and privileged to have you with us today. Welcome to the webinar.
Thank you, sir.
With immense
Thank you.
pleasure. With immense pleasure, now I would like to introduce our today's speaker, Honorable Mr. Justice Rudrappa Bhimappa Budihal. His Lordship graduated from Belgaum College of Commerce, later obtained his master's degree from Karnataka University, and he obtained his law degree from University Law College, Dharwad. His Lordship enrolled as an advocate in the year 1983. His Lordship was nurtured under the aegis of Sri G.H. Chabbi. His Lordship practiced on the civil side and criminal side in the districts of Bijapur and Bagalkot. His Lordship joined Karnataka State Judiciary in the year 1999 as a district judge. His Lordship served as a district and sessions judge in Bengaluru and Gulbarga, and as the principal district and sessions judge in Gadag, Bengaluru and Belgaum districts. His Lordship served as the Registrar Judicial, Registrar Vigilance, and also as the Secretary to the Honorable Chief Justice and as the Registrar General of the Honorable High Court of Karnataka. His Lordship was elevated as the Judge of the High Court of Karnataka in the year 2013 and retired on 30th September 2018. Post-retirement, His Lordship was appointed as the Judicial Member of the Karnataka State Administrative Tribunal. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, sir.
Thank you, sir. Thank you very much for the welcome, sir. Brothers and sisters, whether I am audible,
Please.
I am audible clearly. Very much.
Please, sir.
So for today's discussion, the topic that is assigned to me is appreciation of evidence. According to me, this is the most important chapter that it is to be studied by everyone, and more particularly for the honorable judges, because they have to appreciate the evidence tendered before the honorable courts. If that is so, now when we are say that this topic is appreciation of evidence, without knowing the definition of the term evidence, we cannot go to appreciation aspect. First, we have to see what is evidence. Then only we can come to what is the appreciation to be made by the honorable judges in the courts of law. The section 3 of the Indian Evidence Act, it defines the term evidence in this way, that evidence means and includes, clause number 1, all statements which the court permits are required to be made before it by the witnesses in relation to the fact of a matter under inquiry. Such statements are called as oral evidence. Then clause number 2, all the documents produced before the court for inspection, which is called as a documentary evidence. Therefore, if we consider this definition, which is under section 3 of the Indian Evidence Act, it refers to only two kinds of evidence. One is oral evidence of the parties, and another one is the documentary evidence. Now the question will arise, does it mean to say that there is no other evidence except these two, oral evidence as well as the documentary evidence? You please see that the Evidence Act makes references to admissions and confessions, that they are a relevant piece of evidence. But admissions and confessions, it is neither by the parties made before the court. In that case, what happens now, when it is considered admission and confessions are also considered to be a relevant piece of evidence, then we have to say that this also comes within the purview of the definition of the term evidence. That is the reason section 3, if we carefully analyze the words used in section 3, it is not the exhaustive definition of the term evidence. It doesn't mean to say that this is the only evidence, except this there is no other evidence at all. It is not so, because the word used is evidence means and includes. The word includes is very much important for our discussion. Therefore, when it say that it is also including some other evidence also, admissions and confessions, though there is no reference in the definition part under section 3, but still the confession and admission, they are also coming within the purview of the term evidence. That is the opinion. Then the next question is, there is also another kind of evidence which in English law it is termed as a real evidence. What is that real evidence? You might have seen in a sessions cases what happens now, material objects are going to be produced before the court. It is not only in criminal cases, even it may be very well in the civil cases also. Take for example, in a civil suit, civil proceedings between the husband and wife, if the very marriage is disputed between the couples, suppose there are documentary evidence like a photograph, wedding photographs are there. If they are produced during the course of the proceedings, they will be marked as material objects, or even they may be marked as the documentary evidence. And in a criminal cases, what happens now, you might have seen that the blood-stained cloths are there, blood-stained weapons are there. Like this, in English law, it is termed as a real evidence. Therefore, these kinds of evidences also comes within the purview of the term evidence under section 3 of the Indian Evidence Act. Now we have already discussed that there are only two kinds. One is oral evidence, another is the documentary evidence. If that is so, we can say that the material objects, either it can come in any one of the category, either in the oral evidence or it may come under the documentary evidence. The material objects which are produced, they are considered to be the permanent, they are considered to be the documentary evidence. Therefore, it is only classified under the category of a documentary evidence. Then what do you mean by document then? If you say that material objects, blood-stained cloths, all those things, they were coming under the document, the term document. What do you mean by document? A document is a permanent record of happening of any fact. Happening of a fact is called as a document. If you say that when the murder that has taken place at a particular place, the blood-stained cloths are there, it is a permanent document which is showing about the happening of the fact of murder because of the blood-stained cloths are there, or even the injuries that have been caused to the persons on both the sides or on one side. Like this, weapons can also be produced before the court. This is which is we are calling it as per the English law as a real evidence, but in the Indian evidence we are bringing it and classifying in any one of the category. Either we are placing it in the oral evidence or we are placing it in the documentary evidence according to the nature of the evidence that is produced before the court. Now another question is, when the section 3 refers to oral account of the parties which is tendered before the court is called as a oral evidence. Documents produced by the parties to the suit or the proceeding are in the criminal proceedings, that they are called as a documentary evidence. Now, the situation may come like this. You can take both civil as well as the criminal proceedings. You can refer to one provision under the CRPC, section 310 of the CRPC, local inspection. Local inspection is the provision under the CRPC. It consists of two clauses, clause number 1 and clause number 2. Whenever any judge or the magistrate is requested to visit the spot wherein the incident has taken place, and if the judge proceeded to said place wherein the incident has taken place, or if wanted to see some other places also which is having a relevance according to the opinion of the judge, he will visit. And what he will do, immediately without any further delay, the judge is supposed to draw a memorandum what he has seen on the spot. A sketch is to be drawn by the judge by way of a memorandum, and this memorandum, it is forming a part of the court records. And clause number 2, what it says, the memorandum whatever prepared by the judge, it is to be supplied to both the sides. They must come prepared with regard to the chart is concerned. They are entitled to get the copy of this memorandum, the chart which is drawn by the judge after visiting, after conducting the local inspection in respect of the spot wherein the incident has taken place. So this is also one of the evidence. It comes one of the categories. It is nothing but when a chart is drawn by the judge, It is nothing but we are classifying it and bringing it under the category of a documentary evidence. Come to the CPC. What is the provision under the CPC for the judge to conduct a local inspection in respect of the disputed site? That is Order 18, Rule 18, if I am correct. Order 18, Rule 18 is the relevant provision under the CPC, where also the application may be filed by the parties requesting the Honorable Judge to come to the spot. Therefore, the matter will be more clear if the Honorable Judge visits the spot and the Honorable Judge notices what are the facts existing on the site is concerned. Take for example, in a suit under the Easements Act, making a prayer, either it may be easement of prescription, wherein a declaratory prayer is going to be made by the plaintiff in the suit. And suppose if it is an easement of necessity, in that case what happens? Right of way that is in question of a one party, he claims that he is proceeding to the land by passing through the land of the defendant, but the defendant is going to obstruct his passage. So that was the reason for him. It is a cause of action for the plaintiff to file the suit before the court of law. To make this situation more clear to the judge, Honorable Judge, the parties may file an application before the Honorable Court requesting the Honorable Judge, sir, you please come to the spot, so the things will be more clear for purpose of the appreciation and for writing the judgment is concerned. The Honorable Judge may accept if it feels necessary. Then the Honorable Judge proceeds to the spot and he can conduct the spot inspection and he can prepare the chart here also, which is becoming a memorandum and it is forming a part of the court records. Parties are entitled to get the copies of that memorandum which is drawn by the Honorable Judge, and they can make use of while arguing the case. It can be made use by the Honorable Judge also at the time of writing the judgment is concerned. And here also what happens under the CPC, we are bringing this kind of the category of the evidence, that is a chart, inspection chart drawn by the Honorable Judge under the documentary category. This is how that you have to see that evidence which is mainly referring to only two classes, oral account of the parties before the court and the documents produced by the parties for the inspection of the court. That doesn't mean that it is confined only to these evidence only. It is vast enough. That is the reason for the lawmakers to make use of the word, the means and includes. It means it includes some other aspects also within the purview of the term definition is concerned. This is all we made the reference with regard to the evidence is concerned. Now, any fact and issue before the court, either in a civil proceeding or in a criminal proceeding. Suppose if there is a criminal case and the charge against Mr. A is that he has committed the murder of Mr. B. That is the charge in the criminal trial. What are the facts in issue to be proved by the prosecution during the course of the evidence? That A assaulted B. First, the fact in issue, whether A assaulted Mr. B. Number two, whether A assaulted Mr. B with an intention to cause his murder. That is the second fact in issue. Number three, that Mr. A, when he assaulting Mr. B, he was suffering from some ailments, mental ailments. He was not capable to know the nature of the things, what he is doing, whether it is right or wrong. This is also one of the issues, because what happens now, any criminal act, it is having two elements, important elements. You all know the basic things. To constitute a crime, two things are very much necessary. In case of an agreement under the Indian Contract Act, you are studying two important elements of an agreement is offer and acceptance. Offer and acceptance is equal to agreement. Like that, in a criminal case, to constitute a criminal offense, two things are necessary. One is actus reus, another is mens rea. If there is no mens rea at all, actus reus may be there. There may be a dead body lying, and the person, he may shoot a particular person, but his intention was not to cause the death of that particular person. He wanted to hunt the bird which was sitting on the bush. He aimed at that bird, but suddenly the person who was hiding behind the bush, he suddenly they get up and this bullet hit that person. Maybe there is a actus reus. Dead body is lying, that is the happening of an event. Next question is whether criminal liability is there on the part of the person who shoot that the person is, you can say that there is no mental element at all. There is no mens rea. He never intended to cause the death of Mr. B. It has taken place that he wanted to kill the bird, but incidentally the person hiding behind the bush get up and the bullet hits into that person. If it is established before the court, it will be very clear. Suppose you can take another example. He wanted to kill Mr. A by firing, but suddenly, accidentally, the bullet hits Mr. B, another person. What happens? What happens? Is it a criminal offense or not? His aim is either A or B, doesn't matter, but his intention is to kill the human beings. Therefore, it comes under the criminal, the act, and it is an offense for which he is liable to be punished. This is the way that the judge go on making, and he has to go on appreciating the evidence. But what happens now, as we have already made a reference about the evidences, both oral as well as the documentary evidence. But how the facts are going to be proved before the court of law? Irrespective of the proceeding, either it may be civil or even it may be a criminal proceedings. There are two kinds of evidence by which a fact in issue can be proved. First one is a direct evidence, and second one is circumstantial evidence. These are the two important evidences by which any fact in issue it can be proved. What do you mean by direct evidence? This can be in detail that has been laid down under section 60 of the Indian Evidence Act with regard to the modes of proof. Under the heading, it comes under the modes of proof. What are the different modes for proof of a fact in issue before the court of law? Now, direct evidence. You know that one particular fact can be proved with the help of another fact. Take for example, in a crowded street and the two vehicles are moving in a very high speed. There is a collision of the two vehicles. One vehicle was carrying with the dynamite. Because of the accident, what happens now? The explosion took place all of a sudden. The explosion took place, and because of the huge sound, because of this, the explosion, the nurse in the nearby hospital, she may drop the child. There may be a death of the child. There may be injury to the child. Like this, so many matters, both on criminal as well as the civil side. On the civil side, in the sense of making a compensation against the person who is responsible. All these things, they come before the court of law. So what is the fact in issue before the court so far as this explosion is concerned? The cause and effect of the explosion. What was the cause for this explosion? Who is responsible for causing this? And what is its effect? These are things which are to be reconstructed before the court by way of leading the evidence. If the things are reconstructed before the judge, if the facts are ripened, then only the judge can, about the proved facts, then he can apply the relevant law, then he can come to a conclusion that it is because of this reason that the explosion has taken place. So far as explosion is concerned, we can say that a person who has actually seen the explosion or a person who has actually heard the noise of the explosion, he can be treated as a direct evidence and he can be examined before the court of law and he can give the evidence what he has seen actually, how this incident has taken place, who is responsible for this. He can give the evidence in this way. Therefore, direct evidence, what it says now, it means direct evidence means a fact which without the intervention of any other fact, it is going to prove the fact in issue. That is a direct evidence. Direct evidence means a fact which without the intervention of any other fact is going to prove the fact in the issue. This is called a direct evidence. But now coming to the indirect evidence or the circumstantial evidences are concerned. There is no direct evidence as such. You have to construct you have to create a chain of circumstances. You have to create a complete chain of circumstances about the incident that has taken place, and you can show that it is only the accused and accuser only who is responsible for this incident. Then only the court will rely upon such a circumstantial evidence and it will pronounce the judgment after analyzing the matters before it. Therefore, circumstantial evidence is concerned, the Supreme Court in one decision, the Lordships have defined the circumstantial evidence in very beautiful manner. What the Lordships have said, it is well established that in a circumstantial, in a case rested on a circumstantial evidence, all the circumstances brought by the prosecution must exclusively and inevitably suggest the guilt of an accused. You see the wordings of the Honorable Supreme Court so far as the circumstantial evidence is concerned. It is well established that in a case resting on the circumstantial evidence, all the circumstances brought by the prosecution before the court, they must inevitably and exclusively suggest the guilt of an accused. Next, and there must be no circumstance which is reasonable to be considered consistent with the innocence of the accused. There should be no circumstance which is reasonably considered to be consistent with the innocence of the accused. Antavirbar facts. There should not be such a fact showing the innocence of the accused person. All the facts must inevitably and exclusively they must suggest the guilt of an accused person is the requirement as per the judgment of the Honorable Apex Court so far as the circumstantial evidence is concerned. And even so far as circumstantial evidence, their Lordships have proceeded further to observe that even in a circumstantial evidence, the judge has to bear in mind that he has to consider all the materials collectively and he has to see and to read it as an integrated whole, but not in isolation. You please say what is. What is the method of appreciation in case of circumstantial evidence? What is the duty cast upon the judge for the appreciation of such evidences? The judge has to consider the entire material, all the facts and circumstances brought and record. Cumulatively, he has to consider if all these things could appreciate it together, what is emerging out of the bundle of facts. This is the way that the judge has to appreciate the circumstantial evidence, and their Lordships and as well as the Indian Evidence Act, what it says that sometimes circumstances are more stronger and forceful than the oral evidence of the parties, direct evidence of the parties. Circumstances are sometimes more forceful and very strong compared to the direct evidence of the parties. Man may lie, circumstances may not lie. This is the fundamental so far as the circumstantial evidence is concerned. Man may lie, circumstances never lie. If the chain of circumstances is completely established, then it is sufficient for the court to base the conviction on the basis of such evidence which is established by way of circumstantial evidence is concerned. And it is also observed by their Lordship, any missing link about any particular fact, it is fatal to the prosecution. Because the benefit will go to the accused person. Admittedly, what happens, there are no direct evidence. Court is only relying upon the circumstantial evidence. And if it is not the chain of circumstances is not completely established, if there is any small missing link of the chain, the benefit will have to go to the accused person and he is to be acquitted from the proceedings. This is the law so far as the circumstantial evidence is concerned. And it all depends upon how the court judge is going to appreciate the things in case of circumstantial evidence is concerned, depends upon the facts of each particular case. And while reading, I come across how the courts are capable to draw some inference and the possibility or probability how this court he can draw the inference. That one example that has been given in the book, there was one small village which is touched by the road and the road ends there itself. And the lorry driver during the night who belongs to that particular village, he used to come along with the lorry to have the rest during the night in that village. On the day when the lorry driver brings his lorry, a dead body of a man was lying by the side of the road. And the position and the nature of the injuries on the body, it goes to show that it is clearly visible because there is no dust storm, there is no rain, and there is no any mist. What are the injuries are clearly visible. The injuries also go to show that when the person lie on the ground, one wheel of the vehicle, it also ran over the body of the deceased person. These are the tire marks, they were there on the body. These are clear things which were visible. When this is the incident. Now the question is, who is the person responsible? Whether the person is negligent in driving the vehicle. These are all the fact and issue which are comes before the Honorable Court. Now, another important aspect under the Indian Evidence Act is that parties can lead the evidence only which the evidence is relevant to the fact and issue. The evidence which is extraneous to the fact and issue, it is not admissible in evidence. Even if it is admitted, it is of no use. It is not going to help to decide the fact and issue. Therefore, relevant facts, they are to be placed before the judge during the course of the trial. Irrelevant facts are the facts which are totally unconnected with the case on hand. It is of no use to produce such a facts or evidence before the court is concerned. Now let us take the present example of a lorry driver of a village. Now in this case, suppose the evidence that has been led before the judge or the court during the course of inquiries, a dog was barking when this driver entered the village during the night. You please see how the facts are relevant and irrelevant. I will explain it. What is the fact in the by way of evidence adduced before the judge during the trial is, ಹೇಳ್ತಾರೆ ಒಬ್ರು ಸಾಕ್ಷಿದಾರ ಏನ್ ಹೇಳ್ತಾರೆ, the dog was barking when the lorry driver brings his lorry to the village. Now I will ask you, what is the relevance of this statement or the evidence adduced before the court? What is the relevancy? But you put the things like this. The barking dog made a person to run hastily who come in front of the lorry. Is it not relevant? A barking dog made a person to run hastily because of the fear, and he ran hastily and come in front of the lorry is a relevant fact to come to a certain conclusion by the judge. He can draw some inference on the basis of this. Or you can take the lorry was not having the headlights, or the lorry was having a defective brakes, or the driver was drunk. Are they not the facts which are relevant to the case? These are all relevant facts. That the lorry which come during the night, it was not having the headlights. It may lead to confusion to the driver. He may drive the vehicle at any direction and he can cause the incident. And suppose if the brakes are defective in nature, which is as per the certification issued by the RTO, it was having the defective brakes. That is also maybe the court can, on the basis of such material placed during the course of the evidence, it can draw some conclusion that it is because of the negligent driving of that the lorry driver himself. This is how during the course of the trial that the judge has to control the proceedings, and he, as per the Evidence Act, he has to say only the relevant fact which is very essential for deciding a fact and issue. Such type of evidence must be placed before the court, and all irrelevant the facts, they are not necessary to place before the judge. Like this. And you can take another the example. There is one case, Hardayal versus State of UP. Hardayal versus State of UP is one another case wherein only on the basis of the circumstantial evidence, the accused who was convicted, his conviction was confirmed by the Honorable Supreme Court and he was hanged. What are the factual metrics involved in that particular case is, a person, the husband, he was always ill-treating his wife. He was always ill-treating as well as he was quarreling with his wife. Because of this, she was fed up and she went to her parents' house. And thereafter, this husband, what he has done, he went to the father-in-law and brother-in-law's house. He made a request and he also played a false trick to get back his wife to his house. But even then, the wife refused to join him to his place. Then in that case, what happens now? The husband, while leaving a place, he uttered a word. While going, he uttered a word. I will teach you a lesson of your life. I will teach a lesson to you, all of you, of your life. These are the words uttered by the husband at the time of leaving that place. Subsequently, what happens? Wife's brother's son, a child of 10 years old. Wife's brother's son, a child who was alone in the house. That child, he was kidnapped, he was murdered, and child's dead body, it was found in a well at that village. Then what happens? The factual story that, and some of the facts which were proved before the court are that This person, he was surrounded, accused person was surrounded by the father of the child and other 3 villagers. Totally 4 persons, they surrounded this person. And when they asked what he has confessed before the 4 persons, that is before the father of the child as well as the 3 villagers, he said that yes, I have kidnapped the child and I will return back, I will bring back the child. This was the statement that he has made before the 4 persons. But somehow under the false pretext, he escaped. Subsequently, a case was booked against him, and evidence, when it was placed before the court, these persons, they gave evidence about all these, his admission. He uttered the word while going that he will teach a lesson to the family members of their life. And there was evidence, one lady, she has seen that he was having this child and he was running from the house of the wife's brother. Means he was having the custody of the child as he was running. This is also a proved fact before the court. On the basis of all these things, the court draws the conclusion on the basis of these circumstances that chain is complete, and the session judge has been convicted the person. Subsequently, when the matter was taken up to the Supreme Court, the Honorable Supreme Court said that the trial court is correctly done and he is entitled, the accused is not entitled for acquittal, and whatever the judgment rendered by the trial court is in accordance with the evidence that was placed before the court, is one of the important that judgment that was rendered in that particular case is concerned. This is how that the judges have to appreciate. And you see, the risk of the judge or the presiding officer in all the proceedings, either civil or the criminal, what is the risk? Risk in respect of appreciation of the oral evidence. There is a risk involved. Because so far as the document is concerned, any plea of the party, whether defendant or the plaintiff, if the plea is supported with the documentary evidence, there is no risk for the honorable judge. He can say in his judgment that the contention of the party is supported with the documentary evidence. And you know that Section 91 of the Indian Evidence Act, documentary evidence overrides the oral evidence. That is one of the principles. Therefore, wherever there is a documentary evidence, there is no risk involved for the honorable judge so much. But so far as appreciation of the oral evidence is concerned, it is a very risky job, and the judge must be very cautious and careful while appreciating. First, he has to ascertain the admissibility and non-admissibility of a particular piece of evidence tendered before the honorable judge, and he has to take a decision with regard to these aspects are concerned. Now we made reference to the definition part of what do you mean by evidence. And evidence, it include, though in the definition only 2 classes, oral and documentary, are referred, but how this confession and admission, they are also relevant piece of evidence. Real evidence like a material objects are also coming. Marriage photographs in a civil proceedings are also admissible in proof of the marriage is concerned. By making all these reference, so also how the fact in issue can be proved by producing the direct evidence as well as the indirect evidence, that is the circumstantial evidence. Now we can refer to what do you mean by appreciation of evidence. What do you mean by appreciation? Because we know now at this stage we know what do you mean by evidence. Now the question is appreciation. So how it is defined in the Indian Evidence Act? Appreciation of evidence, it is stated like this: whatever may be the kind of evidence reported to the court through the mouth of the parties by oral evidence or by production of the document, but in either case, the judge has to examine the reliability quotient of the evidence produced. This is appreciation of evidence. I will repeat again. Whatever may be the kind of evidence produced before the judge, that is either by way of the oral evidence through the mouth of the parties or by production of the document, but in either case, judge has to examine and he has to find out the reliability quotient of the evidence produced. This is called appreciation of evidence. It means after seeing the evidence, both oral and documentary, the judge has to use his skill and experience, and he has to find out from out of that evidence which is appealing to him that it is a truthful evidence. It is helping to establish the fact in issue. Only he can rely upon such evidence which is reliable and truthful. So he has to make this choice. He has to make this choice. then only he can pick up such evidence which is appealing to him, and he can say that this is the evidence in proof of the particular charge is concerned. This is called, the process is called as appreciation of the evidence in the civil as well as the criminal proceedings are concerned. Now coming to the admissions and confessions, we have said what is the other relevant piece of evidence under the Indian Evidence Act in proof of the cases under the circumstantial or direct evidence is concerned, is one of the important piece of evidence is dying declaration under section 32 clause 1 of the Indian Evidence Act. Dying declaration. I will make a distinction between confessional statement and the dying declaration. What is the difference between these two pieces of evidence? Dying declaration, section 32 clause 1 of the Indian Evidence Act, what it says, if it is satisfactorily proved before the court, it can be the sole basis of the conviction and no other the corroborative evidence is required so far as dying declaration is concerned. But so far as the confessional statement of an accused is concerned, who confessed before the court that he is admitting the guilt, he committed the crime. In that case, what happens now? The confessional statement, it requires further corroboration. It requires further corroboration from some other evidence. The honorable judge has to compare whether the confessional statement made by an accused person is supported by some other material or not. It requires corroboration from other sources, but not so in case of a dying declaration, because dying declaration once proved satisfactorily, then it is sufficient to base the conviction only on the basis of a dying declaration. This is the distinction between dying declaration and confessional statement of the Indian Evidence Act is concerned. Now coming to the dying declaration aspect is concerned, you know that we all borrowed this principle from England, English law. And for your kind information, whether you have seen or not, I don't know. In our Indian Evidence Act, there is no concept of dying declaration at all. There is no such a concept. I can make this very clear. If you read the wordings of, if you are having the Indian Evidence Act and read section 32 clause 1, there is no word of dying declaration. The principle of dying declaration is not at all there. The word is not there. You please verify that. What it says, any statement made by a declarant about the cause of his death, any statement made by the declarant about the cause of his death or circumstances of any transaction in which death resulted, they are relevant piece of evidence and court can rely upon that. This is the definition part of section 32 clause 1. You please verify. Dying declaration, English principle, it is originally of English principle. We have not used in our Indian Evidence Act under section 32 the same word dying declaration, but instead what we have used, statement made by a declarant explaining about the cause of his death, one part, or circumstances of any transaction in which transaction death has resulted, it is a relevant piece of evidence. Court can permit the parties to lead the evidence, and court, if satisfied that it is satisfactorily established, it can base the conviction only on the basis of the dying declaration. This is the principle. Now, what is the remarkable distinction between English dying declaration principle and our Indian section 32 clause 1 statement relating to cause of death? What are the remarkable distinction between the two? Can anybody? Distinction between English dying declaration and also the Indian section 32 clause 1 statement relating to cause of death of a person. There are two remarkable distinctions between the two. Two remarkable distinctions between English law of dying declaration and our section 32 clause 1. What are those two the distinctive features? First one, under the English dying declaration, what happens now? The declarant must make the statement without having any the hopes of his survival in future. Meaning thereby, under the English law, the declarant must make the statement without having any expectation of his survival. Under the hopeless expectation of death, he must make the statement. That is required under the English law. And English law also says that if the declarant is having any faint chances of his survival in future, the statement is not admissible as a dying declaration. But in our Indian section 32 clause 1, that is not the requirement at all. That he must make the statement under the settled and hopeless expectation of that. That is not the requirement of our Indian law. What our law is says that a person who made statement regarding the cause of his death, after his death, his statement becomes relevant as a dying declaration. This is our law. Why this distinction has been made with the English dying declaration and our Indian the statement under section 32? Why such a first the distinction has been made? What the English law says is, under the English law, it must be admissible only when if the declarant made the statement under the settled hopeless expectation of death, then only it is admissible. Even only a small faint chances of his survival in future, it will not be admissible as a dying declaration. But Indian lawmakers, they made a comment that this English principle of dying declaration is most artificial, because how we can know it is a mental condition of a person? Under what expectation he has made the statement? How can you go into the mind of a declarant and you can ascertain that it is made under the hopeless expectation of death or not? Therefore, to that extent, the Indian definition of dying declaration, it is most that artificial. Therefore, our Indian lawmakers, they have avoided the using of this word in our Indian the Evidence Act, like the section 32 clause 1. In its place, instead of using the term dying declaration, we used that statement relating to statement made by the declarant relating to his cause of death or circumstances of any transaction in which death resulted. It is a relevant piece of evidence, and the court can admit upon the dying declaration and it can base its conviction, is also one of the important principle under the dying declaration is concerned. Now you know that being the advocates and we being the judges, that in every case what happens now about the admissibility of the dying declaration, so many that the decisions are there of the high courts as well as on the Supreme Court, whether it is to be admitted or it is not to be admitted, because it is not proved by the prosecution that the declarant was in a position to make such a statement because his throat was cut. How he was in a position to speak something. These are all some of the things which were argued by the counsels on the both the sides, prosecution as well as the defense, and even so many judgments from the courts of law. This is all the process is going on, and you may also taking the contention that the doctor's certificate is not there to the dying declaration. At the end and in the beginning, it must be have the certification by the doctor regarding the mental condition of the declarant, that he was competent and conscious, mental consciousness to make such a statement. Such a certification, it was not there. Therefore, the dying declaration, it was not at all admissible in evidence. Maybe the line of argument by so many the learned members of the bar. But for this, what happens now? Maybe there are so many decisions. Ultimately, in the year 2002, the Constitution Bench of the Honorable Supreme Court, it delivered one judgment. 5 judges of the Honorable Supreme Court, they delivered the judgment on the dying declaration, and it is reported in AIR 2002 Supreme Court. AIR 2002 Supreme Court, page number 2973. And I am making a request to all the members of the bar and all other persons who have joined. You please read this judgment, important judgment of the Honorable Supreme Court, how the Honorable Supreme Court, the Constitutional Bench has discussed about the relevancy and admissibility of the dying declaration, and whether certification is a mandate of law or it is only a rule of caution, and if certification is not there, whether it is admissible or not. Suppose dying declaration, it doesn't bear the signature of the declarant. All these circumstances, they have been extensively considered by the Constitution Bench of the Honorable Supreme Court, and ultimately their lordships have delivered one important judgment about the dying declaration is concerned. Now, on the basis of this, the one important judgment which I am requesting you to read, Pakal Narayan Swami versus Emperor is the case. Pakal Narayan Swami versus Emperor is the case on the dying declaration. How the courts, the Privy Council, the matter comes up before the Privy Council. It was in the year 1939. The case come up before the Honorable, the Privy Council in the year 1939. And there is a reported judgment on that aspect, a very beautiful judgment, which that judgment also analyzed the principle of about the dying declaration, how it is to be analyzed and how the parties are permitted to adduce the evidence and how the court can act upon such evidence and base the conviction or acquittal of an accused person. It has been discussed at length. The factual metrics in that particular decision are to this extent. The wife of the accused, there was one accused, his wife, she was indebted to the deceased. Wife of the accused was indebted to the deceased person to the extent of 3,000 rupees. It means wife of the accused borrowed rupees 3,000 from the deceased person. And the wife of the accused person, she was writing so many letters to the deceased, which were recovered during the course of investigation. And lastly, there was one such letter, but that letter lastly written, it was not signed by anybody. There is no signature of anybody on this letter. What are the contents of this letter? The deceased was requested to come to Baranpur to receive the amount. This is the contents of the letter. And when he received the letter, the deceased person, he shown this letter. His name is KN. The deceased name is KN. And he shown this letter to his wife. And he told that while leaving the house, he told the wife, I have received the letter. I was invited to come to Barampur to receive the amount. Therefore, I am going to receive the amount. These are the words deceased made before his wife. And he left. It was on 20th March, 1937. 20th March 1937, when the letter has been received. On 21st, he left to go to Barampur by train. Then what happens on 23rd of March? On 23rd of March, the dead body of the deceased, it was found in a trunk. It was found in a trunk which was cut into 7 pieces. The body of the deceased was cut into 7 pieces, and this body, it was put into the trunk, and the trunk was left in the 3rd class compartment. These are the factual story. And the case was booked. When the matter, it was before the court, what was the evidence adduced is all the circumstances. And one of the circumstances that this accused person, he purchased this trunk through one washerman, that is the dhobi. With the help of the dhobi, the accused person purchased the trunk. And some blood-stained cloths were also recovered. These are the proved facts before the trial court. And subsequently what happens? During the course of the trial, the prosecution wanted to lead the evidence on the letter which the deceased received and he has shown to the wife. Objection was raised by the defense side. It is not a dying declaration. The contents of the letter are not a dying declaration. Therefore, the letter is not admissible in evidence is the serious objection raised by the defense. But however, the trial court allowed the letter to be produced, and it was marked, it was considered for while writing the judgment. Another important that was challenged before the Privy Council, 2 important aspects were challenged about the judgment of the trial court before the Privy Council. Another one is, accused made some statement before the police. Accused made some statement before the police, and even with regard to that statement also about the admissibility, the defense raised the objection that the statement of an accused made before the police is not admissible. Even then it is wrongly admitted is also one of the points that was canvassed before the Privy Council. Now the Privy Council who wrote the judgment, you please go through the judgment of the Privy Council and about these 2 important contentions, how the dying declaration has been considered and appreciated by the Privy Council, that we all know, you also know that we are mainly concentrating, whenever the dying declaration comes, we are mainly concentrating only on the first part of the dying declaration. Section 32 clause 1, first part. What is the first part? Any declaration made by the person about the cause of his death. we are stopping there itself. We are stopping there itself. That it is amounting to, after the death of the declarant, it becomes a dying declaration. We are considering like that. But now, so far as the contents of the letter is concerned, you please see, you please apply your mind. The prosecution, it produced the letter, contents of the letter, it was produced before the trial court. A serious objection was taken. In the contents of letter, where is it written the declaration that the cause of death is there? It is not there. What are the contents of the letter? He was invited, deceased was invited to come to Barampur to receive the amount. That's all. How this will be coming under the purview of section 32 clause 1 as a dying declaration was a serious objection raised by the defense so far as the production of that letter before the trial court is concerned. But even then, I have already told, somehow the trial judge allowed that letter, treating that it is a relevant piece of evidence under section 32 clause 1. And another contention that I have also brought to your notice, that statement made by an accused person, the Pakalu Narayan Swami, he made the statement during the investigation before the police officer, and that statement, it was also opposed during the course of the trial before the trial court, that it is also not admissible. But both were admitted, and ultimately Pakalu Narayan Swami was convicted. And when the matter was taken before the Honorable Privy Council, so far as the first contention is concerned, you please see, the Privy Council decided the matter referring to the second part of section 32 clause 1. You please now apply your mind. Second part of the section 32, it refers to what? Of any transaction, circumstances of a transaction, in which transaction death resulted. Under that second part, the Privy Council said, it is one transaction, that deceased advancing the loan to the wife of the accused, she addressing a letter continuously, last letter also she addressed, with all probability, with all human probability, it can be ascertained that though it is not signed, but it is definitely by the wife of the accused person, addressed to this deceased. So the Privy Council says that it is one series of a transaction, in which transaction death is resulted, because he proceeded on the basis of contents of the letter to Barampur, wherein he was murdered. His body was cut into pieces and filled into the trunk, and trunk was left in a third class compartment which is unclaimed by anybody. Therefore, the Privy Council says trial court correctly admitted the contents of the letter because it comes under part 2 of section 32 clause 1 as a dying declaration. Therefore, it is admissible in evidence. But so far as second contention of the accused is concerned before the Privy Council, that giving admission to his statement given before the police during investigation. But so the Privy Council said, so far as this statement is concerned, it is not admissible. It is wrongly admitted by the trial court. Referring to section 162 of the CRPC, you please see. Section 162 of the CRPC, the Privy Council says, such a statement made by an accused person before the police, that too during investigation, it is not at all admissible in evidence. Therefore, it is wrongly admitted. But even then, the Privy Council said, even if that part is excluded, but the remaining part is sufficient to base the conviction. Accordingly, the trial court has correctly convicted the accused person. The conviction has been confirmed, and the accused person was hanged. This is how the dying declaration principle that I have already told, if it is satisfactorily established before the court with a cogent evidence, then it can form the sole basis for conviction of an accused person. But it is not so in case of the confessional statements are concerned. I have already told, confessional statement of an accused person, that cannot be a sole basis. It requires further corroboration from any other evidence. Then only the judge can come to a conclusion. The confessionary coupled with corroborative evidence, it is sufficient to hold that the accuser has committed the particular crime or he has not committed a particular crime. And so far as the confessional statements are concerned, you see, we are referring to the relevant provision under the CRPC section 164. Section 164 is the provision for recording the confessional statement of an accused person, isn't it? What section 163 subclass 3, 164 subclass 3, what it says? What is the mandatory provision under 164 subclass 3? There is a mandate on the part of the judge who is going to record the confessional statement of an accused person. What is the duty on the part of the judge? Whenever a person come before the court that he wanted to make a confessional statement admitting the guilt, first, without recording that, the judge or the magistrate must give a statutory warning to the accused person. What is the warning? Mister, you are not supposed to give any such statement under the law. You are not supposed to admit the crime or the guilt. You please think over the matter. If in spite of that, if you give the statement, same will be recorded and it will be used as an evidence against you. This is the statutory warning to be given by the judge or the magistrate. Then the accused person, he must be removed from the police custody and he must be sent to the judicial custody. Some reasonable time must be given for him to think over the matter. After thinking over the matter, after 2 days or 3 days, whatever the time given by allotted by the court, he can come before the court again, and if he wanted to make the confession statement, definitely the same will be recorded on the basis of which the conviction can be given by the judge. This is the procedural aspect under the CRPC for recording the confession statement of the accused person. Now, why this statutory warning is there? Why the statutory warning judge has to give that directly he should not record the confession, the statement. First, he should give the statutory warning, give him a reasonable time. Then only if he comes and made again the second time that he wanted to make, then only it has to be recorded. What is the reason for the legislators to lay such a condition? Can anybody? What is the reason for that? Suppose, for example, it may be true. If it is in respect of a layman, we can say that yes, he is a layman, he doesn't know the law. If he makes such a statement, what will be its consequences? He has no knowledge at all. He is a layman. Therefore, if he comes before the court and made such a statement and warning is given, yes, all right, we can understand that. There is a reason for that. Because he is a layman, doesn't know. But if a person who is suppose he is expert in law, he is a law graduate, he knows law better than all of us. If such a person come before the judge and he wanted to make a confessional statement admitting the guilt, why again, even though he knows better than us about the legal provisions, why the statutory warning again is to be given by the magistrate or the judge before recording the confessional statement? Is anybody? You please see why such a statutory warning is imposed on the judge or the magistrate before recording the confessional statement. This is having a historical background. It is having its own historical background. You see, in England, what happens? At a particular spot, the murder took place. At a particular spot, one murder took place. And when the police rushed to the spot, they found that one woman, old lady, that she was by the side of the dead body, she was having the knife, which was bloodstained in her hand. Then she was brought before the British courts. And judge asked her, then she made the confession statement that it is she who committed the murder of that particular person. It was straightway recorded. Then she was convicted. She was sent to the jail. Then after 2-3 days, at another spot, there was another murder. In the second murder, another person, a male person was caught hold and he was brought before the judge. During the trial of that person, when the trial was going on upon the second time murder case against a male person, when he was admitting the guilt before the judge, he said that it is not only this murder, I have also committed the previous murder. He made such a statement before the court. Then the judge was wondered. Then why that lady, she made the confession statement, we have already convicted her and we have sent her to the jail. What is this? This man is telling that it is not only this murder, he has also committed the previous murder. And under the British law, that there is a provision for the reopening the trial, which is ended in a conviction. Then that lady was summoned. Who was who was undergoing the sentence, she was summoned again before the court. When she was brought second time before the court, she made a correct the statement before the judge that I have not committed that murder. Then why you made such a statement that you admitting the guilt and we recorded and we have already punished you and sent you to jail? She said, true, I made such a statement. It is for what reason? Under the British law, if there are no other person to take care of their minor children, it is the British government taking the care of such children. If there is nobody to take care, and she was also having the children, her ambition was that, like all other persons, my children must also be highly educated and they must be placed in a high position. This was her desire. And thinking that if I admit and go to the jail, there is nobody for my children, and it is the British government taking the care of my children, and they are educating, then she said, this is my intention. Because of this intention, I have made the confession statement, even though I have not committed the murder in reality. Then the legislators thought about this seriously, that man may confess because of his own ends. This is the principle. Man may make a confession because of his own ends. ತನ್ನ ಸ್ವಾರ್ಥ ಸಾಧಿಸಲಿಕ್ಕೆ ಮನುಷ್ಯ ಮಾಡಿದಿದ್ರು ಕೂಡ ಮಾಡಿಲ್ಲಂತ ಅಡ್ಮಿಟ್ ಮಾಡೋ ಸಾಧ್ಯತೆ ಇರ್ತದೆ. This is a possibility. That is the reason, having this historical background, with this background, now what happens now? Such a statutory warning is laid down under section 164 subclass 3 of the CRPC, that it should not be accepted directly, because even though a person not committed such a murder, but he, because of so many reasons, because of his own ends, swartha, tana swartha sadhanegagi, he may admit the guilt. Therefore the court must be cautious. Statutory warning is to be given. Then only such a person, that he is to be tried, and the whatever the punishment as per the proof that is placed before the court has to proceed. This is how it is having the section 164 subclass 3 is having its own historical background. So this is all with regard to confessional statement, how it is to be recorded. And I have also made a distinction between confessional statement, its evidential value, and the dying declaration. The distinction that I have made, how this requires corroboration, that the confession, but dying declaration, it doesn't require any corroboration. It can be the sole basis. This is how the judge, he has to appreciate the things whenever the cases come before the honorable judge. Now, for the judge, there is some other difficulties during the course of the trial. What are the difficulties? You all know that about the witnesses cited. What is the allegation? No, these are all the witnesses who are the relatives of the deceased. These are all the witnesses who belongs to the deceased. They are relatives, parties and witnesses. They are having enmity towards the accused person. These are all some sort of allegations they are going to be made. This is one aspect. Secondly, the witnesses are giving the statement before the police during investigation at one time. Whenever they are put into the box during the course of the trial, there is some improved version will be there. Improved version will be there. Therefore, the Honorable Supreme Court, what it says, the judge must be very cautious. Even if there is some improvement or a contradiction between his statement before the police and during the course of the trial, the judge has to apply his mind whether it will go to the very root of the case or it is a minor discrepancy in the evidence of the witnesses. If the judge is of the opinion that it is a minor discrepancy, just ignore it. The judge has to proceed on the basis of the evidence. But if opinion of the judge is it goes to the very root of the case, it is fatal to the prosecution and the benefit will be given to the accused person, and accused is going to be acquitted. This is how the judge has to make the appreciation about all these things. There may be some minor discrepancy. I can say that there is one state, the witness is stating one thing before the investigation officer. What he has stated, I have seen blows being given. I have seen blows being given to the deceased. This is his statement before the police. But whereas in the evidence in the witness box, what he says, I have seen accused was attempting to beat the deceased. So there is a variation there is a discrepancy, but even then, the Supreme Court said in that particular case, I have gone through the reasoning of the Supreme Court, this itself will not come in the way of the prosecution case. It is a minor discrepancy. It can be just ignored by the court, and the court can proceed with the rest of the evidence that is recorded, and it is placed before the court is concerned. This is how that we have made some discussion with regards to appreciation of evidence. Firstly, with regard to what do you mean by evidence, then how it is to be appreciated, and what is the meaning of appreciation of the evidence under the Indian Evidence Act, applicable to both civil as well as the criminal proceedings are concerned. Yes, any difficulty and questions, you can raise the questions.
Thank you, sir, for an extremely informative presentation. Can we now start with the Q&A session?
Yeah.
The first question, please.
Yes.
First online question.
Yes.
All right, Professor Ransa Vasati. Madam, I have unmuted you. You may quickly pose your question.
Good evening, sir.
Yes, sir. Yes, madam.
Am I audible? Sir, good evening, sir. It was a very excellent thing, sir, for especially for youngsters. You were like, it was everything was at the tip of your lips. And if the youngsters
madam, your voice is not so clear. Your voice is not clear, madam. You please correct it.
Now,
yes,
sir,
madam.
am I audible?
Yes, what is the question, madam?
Sir, now I'm audible, sir.
What is the question?
Sir, am I audible?
You're audible, ma'am, but the quality of your voice is not good. So
yeah.
I'll hold you for some time, and I'll put you again. I'll unmute you in a while.
Yeah.
Okay, sir.
All right. Can we have the next question, please?
Yes, sir.
Can we quickly have the next question? Yes, I see a couple of them. They have raised their hands. Mr. Ankita Srivastava. Ma'am, I have allowed you to talk. You may quickly pose your question.
Yes.
Ms. Ankita Srivastava, I have unmuted you. All right, Mr. Nitin. Mr. Nitin, I have unmuted.
Thank you, sir.
Yes.
Yes, thank you. Am I audible, sir?
You're very much
you are
audible,
audible, Mr. Nitin. You are audible, sir.
Yeah. Thank you very much. It was a very nice lecture. Sir, my question was actually to this, that about a dying declaration. Most of the times what we find is that for example, let us say a wife has committed suicide and she is leaving a suicidal note. In that case, mostly the witnesses are from her family, brother or sister or her parents. But she was, I mean, there was a cruelty incident also. So whether this impacts the case for the conviction of the accused. Thank you, sir.
Yes, I will come to that aspect, Mr. Nitin. This dying declaration, what is the basis of this dying declaration? First, we have to consider that. Basis of a dying declaration. This was discussed by the British court in R versus Woodcock. British court in R versus Woodcock. That was in the year 1789. In R versus Woodcock case, this matter comes up. That what happens now, there was the accused was that he was tried for the committing murder of his wife. And the magistrate immediately recorded the statement of the wife, wherein she was repeatedly that she was making accusation against her husband. And she was very conscious when she was making the statement. Ultimately, what happens now, the judge in that particular case who laid down the basis for this dying declaration principle for the first time is C.B. Iyer is the judge. C.B. Iyer, E-Y-R-E, Iyer C.B. is the British judge. In R versus Woodcock, in this particular case, the judge has laid down the basis for this dying declaration. What are the basis on which we are going to rely upon the dying declaration is, These are the declarations made by the declarant at extremity. These are the declarations made by the declarant when he was at the point of death. These are the declarations made by the declarant when the declarant lost all his worldly hopes on this world. Next, these are the declarations wherein motive to falsehood is completely silenced. And the last one, when the mind of a person is most influenced by powerful consideration to speak the truth. These are the basis for the dying declaration, that we are relying upon the dying declaration, meaning thereby a dying man never say lie. A dying man never say lie. Because you please see the basis. Again I will repeat. These are the declarations made by the declarant in extremity. When the declarant is at the point of death. When the declarant lost all his hopes of this worldly affair. Next, when motive to speak falsehood is completely silenced. And next, last one, when the mind is influenced by most powerful consideration to speak truth. Under such circumstances, when a person is making a declaration, it cannot be a falsehood. It can be a truth. And though this may be the principle or the basis, but to come to a conclusion about a dying declaration in a particular case, it is the discretion of the judge. Depends upon what is the evidence adduced before the particular judge. What is the evidence adduced in that particular case? Whether the evidence adduced by the prosecution is of such a nature that it is going to prove the dying declaration that really it is a statement of a dead man, or the prosecution has not led any evidence that it is the evidence that which the reliance can be placed by the court. Therefore, the discretion is with the judge, depends upon what type of evidence was adduced before the court. We cannot lay a hard and fast or the jacket of the formula that in all cases that this is the formula that is to be applied. No, it is not like that. Depends upon material produced in each and every case. If all the material put together and appreciated by the judge, it are going to suggest that really this is the statement left by the deceased, then it can be relied upon. If there is no such a evidence placed, or it is because of some other reason, or there is a falsehoodness because of some other persons who are involved or meddled in that process of making dying declaration, then the court can reject the dying declaration. Not necessarily that in all cases it is to be relied upon. Question is with the proof. If it is proved, it can be relied upon. If it is not proved, then it can be rejected. That's all. Yes.
Yes, sir. Thank you very much. Now we have Mr. Shrikanteshwar, advocate, who has a question.
Yes,
sir, I have unmuted you.
So good evening, sir.
Good evening, sir.
Sir, evidence is very crucial in case in the criminal trial.
Yes, sir.
But what about the presumption provisions, sir? Can you kindly enlighten us with respect to presumptive provisions in deciding a criminal case? Presumptive provisions, sir.
No. You see, in deciding a criminal case, I have already made my submission that it is for the judge to apply his mind to all the material that was placed before the judge during the course of the trial.
Okay, sir.
On the basis of that, he has to take a decision in the matter. I have already told that there cannot be a straight jacket formula in each and every case that this should be the appreciation, because it all depends upon the evidence placed before the judge. And we cannot say that in all the cases the similar type of evidence is going to be produced. Yes.
So, don't you think, sir, presumptive provisions would cause prejudice to the accused?
How, sir?
That is available in the law? Presumptive provisions?
How it is going to cause prejudice, sir, according to you?
They are not the real facts, sir. That is what I think so. Those are presumptive provisions. Is not a real fact. It is just a presumption. But then law provides presumptions.
No, you please see. Only on the basis of presumption, the judge is not going to proceed to base the conviction, sir.
Okay.
How can on the basis of presumption, how the judge is going to hold that the accused is guilty for this offense?
Okay.
It is not only on the basis of the presumptions. It is only on the basis of concrete evidence that is placed before the judge.
Okay. Okay. Okay, sir. Thank you, sir.
Yeah.
Thank you, sir. Thank you.
Thank you.
Thank you, sir. Mr. Ashok Kumar, I have unmuted you. You may quickly ask your question.
Yes, sir.
Good evening, sir. Very good
Good
lecture.
evening, sir.
Your
Good
depth,
evening, Ashok Kumar.
your depth knowledge of case law with the examples is unforgettable in our day-to-day life.
Thank
My
you, sir.
question
Thank
is,
you. Yes.
can a oral evidence with a chain of circumstances can overweight the documentary evidence? I will repeat.
No, so far as suppose you see, in respect of which fact the evidence has been given before the court, suppose it is covered by the document, then oral evidence cannot overtake that documentary evidence. Because provision is very clear. Section 91 of the Indian Evidence Act, documentary evidence always overrides the oral evidence. Oral evidence the judge can rely upon in respect of those facts wherein it is not covered by the documents. If the fact in respect of which the document is produced, if it is covered under the document, there is no question of they placing the oral evidence, overtaking this documentary evidence, sir.
Thank you, sir. Can we have the next online question, please?
Yes, sir.
I think we have offline questions, sir. Let me just go through. Mr. Mahesh has a question. What is the extent of scope of statement made under section 161 as evidence in a trial? Can that statement can be exhibited in trial?
Yes, sir.
The scope of section 161.
Yes. 161, the statement is going to be recorded under the CRPC during the course of investigation of the witnesses. 161 statement of the witnesses going to be recorded by the investigation officer during the course of the investigation. And when the charge sheet is filed, this 161 statement is also forming part of the charge sheet material. And during the course of the trial, how the 161 statement can be made use by the parties, by the prosecution for the purpose of corroboration, by the defense for the purpose of contradiction. That's all. And once the evidence is over, the 161 statement loses its importance.
Thank you, sir.
It can be made during the course of the trial by both the parties, prosecution for corroboration and defense for the purpose of contradiction. That's all.
Ms. Surabhi has a very different question. I'm afraid, but I would just read it out for you. Whether section 32 of Indian Evidence Act is applicable to civil cases, I would be grateful if you could answer this, sir.
Which one, sir? What is, you repeat the question, sir?
Whether section 32 of the Indian Evidence Act is applicable to civil cases. I would be grateful if you could answer this. Yes.
Yes, sir. Civil cases also it is applicable because it is the biggest section. Section 32 consists of, I think, according to me, 8 subclauses.
Absolutely.
8 subclauses, and one of the clauses with regard, suppose there is a suit filed based on accounts, partnership firm or the company, depending upon the accounts, if a suit is filed by one party, then in that case the account books are relevant piece of evidence which are maintained in a regular course of business. They are admissible and they are relevant piece of evidence under section 32, and that material that it will be a relevant piece of evidence in case if the conditions laid down under section 32 are fulfilled, meaning thereby if a person handled those documents, he is not capable to brought him before the court for so many reasons, that he is suppose abroad, and it will be very costly affair only for the purpose of, suppose a suit is of the value of rupees 40,000, 50,000, and if you wanted to be brought from the foreign countries, the cost of travel itself is it will be in more than lakhs. And if the person completely becomes incapable to come before the court and give the evidence because of his extreme old age and all those things, the accounts maintained, and if it is established that this is maintained during the course of the business of the partnership firm or the company, they are having a relevancy and they are admissible in evidence.
Thank you, sir. Sri Prasad has a question.
Yes,
please enlighten on oral dying declarations. Most of the time, I think it would be oral.
Yes, sir.
The question is
Dying declaration. You please see regarding the types of the dying declaration, either it may be oral or it may be documentary or even it may be by the signs. The deceased person, he can make a sign before the person who is going to record a statement that a accused person was a bearded person, gada vitavida. Like this, he can make a sign. Even by sign also he can. And the oral account, sometimes what happens, take for example, you have raised a very good question. Always it is not possible to record the statement or reduce the statement into writing by magistrate clerks or some other person. Take a remote village which is not having the facility of approaching, roads are not there, vehicles are not coming. In such a remote village, if a person is going to die because of some reason, and the person is making some oral dying declaration before the somebody who are present, that another person, he can come and give the evidence before the court regarding the oral dying declaration. But now the question is, how far the court has to believe it is, how the satisfactory manner the oral account is placed before the honorable court is the matter for appreciation before the judge. Because the court has to, it must be acceptable to the conscience of the court. Because when you say that it is oral, it doesn't mean that always the dying declaration must be in a written form. There are many kinds of the dying declaration. It may be very well oral. You can take any other business transaction. You leave this dying declaration. Contract, you can come. Is there any necessity under the Indian Contract Act? Always the contract between the two persons must be in a written document? No. Even it may be oral also. But the question is, proof of such oral dying declaration, how far it is believable? What is the evidence given by the person who stated that in his presence the oral account has been made with regard to the cause of death of that person? This is the law.
Thank you, sir. Mr. Chandrasekhar has a very valid question. The appreciation of evidence by a judge before whom the trial takes place will be different from the judge who just have to give judgment by looking into the evidence before him. Is it not adversity on the outcome of the finally in such cases?
Sir, I will also agree for that to some extent. What happens now, you take both civil proceeding as well as the criminal proceeding. The judge who recorded the evidence, if he proceeded to write the judgment, he will be in a better position. For example, in a civil suit, the bank filed a suit, recovery suit against the defendant. And when the bank lawyer, he wanted to confront some documents to the defendant who was in a box during the course of the trial. The defendant refused to look into the document. His conduct was like this. Even he was not prepared to see the document which is tendered by the advocate appearing on the side of the bank. What is his conduct? So for this, the judges, trial judges are having the one benefit. They can record even the demeanor of the witnesses during the course of the trial. Demeanor of the witness, the conduct of the witness, when he was placed into the box, what was his feelings? What was his conduct? What are his body language? These are all the benefits and advantages available only to the trial judge. So also in a criminal case, demeanor can be very well, it can be recorded. It can be made part of the depositions. Usually what happens now, when a demeanor of the conduct, regarding the conduct and demeanor, when the court is going to record, in the bracket, in the deposition, it will be put into the bracket. At that time, when the counsel for the bank lawyer, when he confronted one particular document to show the signature and the admitted amount in that, the defendant told, he turned back. Even he was not prepared to look into the document. So you see section 8 Indian Evidence Act, what it says, motive, preparation and conduct is the relevant facts which are admissible in evidence. Motive, preparation and conduct. Conduct of a person, how he behaves. What is his conduct during the course of the trial? What is his demeanor before the judge? To that extent, I fully agree with the person who raised that question, that the judge who transferred to that particular court subsequently, and when he has not recorded the evidences of the witnesses, he may be not in such a better position like the earlier judge who has recorded, because he know it was his personal knowledge also how the witnesses, they have tendered their evidence before the court. But it may affect to some extent. I can say only this much. But the another judge who subsequently come also, he can read the deposition and all other things. He can have the mastery, marshalling the facts of that particular case, and he can proceed to pass the judgment. Because what happens now, this is happening. Transfers are going to take place of the judicial officers. We cannot say that one judge who is posted to particular court, always he should be allowed to work in that particular. No, it is not. It is humanly impossible. Under the rules also, transfer is an incident of the government service. He has to go wherever he is going to be transferred to, whichever court that he is going to. But as you said, to certain extent, only to the minimum, it may have its impact. But a better judge, even he can write a judgment more better than the judge who has recorded the evidence. Such examples are also there. Depends upon how the judges are marshalling the facts of that particular case, how they are reading each and every provision, each and every sentence of the deposition. They can write a better judgment. Yes.
So thank you very much. Before we conclude, I see Mr. Gupta sir raising his hand. Sir, I'll unmute you. With that, we will be ending today's Q&A session. Yes, sir, I have unmuted you.
Sir, I'm very grateful to all the office bearers of the Advocates Association, including your president, Secretary Gangadharaya, your the other office bearers, and all the advocate members, all other persons, my brothers and sisters who have joined the webinar for the lecture, and you have patiently heard me, and whatever the little knowledge that God has given to me, that I have shared with all of you. One cannot claim that we are experts, because it is said that no man on this earth ever mastered on all the sciences of this world. Human knowledge is fallible, it is limited. In an ocean of knowledge, it is not sure whether we are at least one drop of that knowledge of the ocean. And whatever little knowledge that I have acquired because of my experience as a judge of the trial court as well as the high court, and with your cooperation, that whatever I have earned, I have placed and I have shared with all the persons and my brothers and sisters. And thank you very much. Grateful to all of you, sir. Thank you.
Sir, Gupta sir has a question. Before we conclude the session, Mr. Gupta sir has a question.
Yes, sir. Gupta sir.
You have taken us to our law college days, sir. You have got a reservoir of knowledge in the evidence law.
No, now, Gupta Sahib, it is all because of your blessings on me.
No, mine was the first case when you came to Bangalore, and your first appointment, sir.
Yes, sir. Okay. But I remember, and I can recollect my memory that you appeared before me in the city civil court, sir.
Yes, sir. Yes, sir.
Yes.
Then now I have a question, sir.
Yes, sir.
Ancient document. Ancient document.
Yes, sir.
How to prove the ancient document?
Ancient document that we have to come regarding the proof of the document, the provisions under the Indian Evidence Act, we have to come, sir. If the document is ancient, if it is 30 years old,
it is more than 30 years old. It is more than 30 years
30
old.
years old, ancient document. In that case, Section 30 of the Indian Evidence Act is the relevant provision. There are certain presumptions. What are the presumptions in favor of the person who is relying upon such documents? Because it is 30 years old, certain presumptions with regard to the writings and the person who wrote, the scribe, and the writings, it is to be presumed that it is written by such a the person whose name appears in the document. And if at all any person wanted to challenge about this validity or genuineness of this document, always the burden is upon the opposite party to establish before the court.
It's only rebuttal evidence.
Yes, sir.
It's
yes,
rebuttal.
Yes.
Thank you, sir. I request, sir, one day you take only on the civil side, sir. You today have taken us the criminal side. One day you have to take the civil side, sir.
Okay, sir. Okay. Thank you. Thank you, sir.
Thank you, sir. Sir, on behalf of Advocates Association Bengaluru, I extend my sincere gratitude, sir. Amid your very tight schedule, you have accommodated us and you have presented a very informative presentation. Thank you so much, sir.
And my regards to you, please convey my regards to the President, Mr. A.P. Ranganath Apko, all the Gangadharaya, other office bearers, the treasurers. I am grateful, sir.
Thank you, sir. Thank you so much, sir. With your permission now, sir, I will be signing off today's webinar.